Good morning. We are in week 6. We are on chapter 5 this week, and chapter 5 is the first of 2 chapters dealing with defenses to criminal liability. There are 2 kinds of defenses. There's justification defenses, and there are excuse defenses. But the underlying premise of both of these are that the defendant admits they were responsible for the action, the actus reus, but under the circumstances, what they did was right for justification defense. So, and under excuse defense, that the conduct was excusable. Okay, so that's the difference here. But the premise for both of these is that the defendant admits that they are responsible for the actions, but they maintain we shouldn't punish them for some other reason. These are both affirmative defenses, which are the defendants have to put forth some evidence on their behalf. If it's a perfect defense, then the defendant is acquitted. If it's imperfect, then the defendant fails to establish the full defense, but they show enough to mitigate their liability. So they're kind of held responsible for a lesser crime. And those mitigation circumstances are things that convince the judge or the jury that the defendant does not deserve the maximum punishment of the crime they're charged with. So our first justification defense is self-defense. And self-defense can be a little complicated and a little narrow, so make sure that you ask questions if you have any. To start off, we have to have 3 circumstances that exist. We need to have that the necessity is great, the necessity for self-defense exists right now, and that the self-defense is for prevention only. So this means that you cannot preemptively hurt someone to stop them from hurting you. This means that you can't retaliate against someone later on, and that you're acting to defend yourself right now. So those are the circumstances that need to exist. And then self-defense has 4 elements. The first element is that you have to be the non-aggressor to claim self-defense. You cannot have started the fight. You need to be responding to somebody else's behavior. Necessity means that you can only use deadly force to repel an imminent deadly attack. So you cannot use deadly force for lesser force. You need to match, which kind of brings us to the idea of proportionality. You need to use the appropriate amount of force to stop the attack, but you're not allowed to use more than that. You can't just use deadly force whenever you would like to. And the last element is that there's a reasonable belief. You reasonably believe that you need to use the force. So your book has an example that's pretty straightforward about whether or not someone is a non-aggressor. It's dealing with Maya Beatty and whether or not she started the domestic violence incident because she claimed that she responded with self-defense. Your case also has a book about a sneak attack, about whether or not that was self-defense, and in it we have a prison inmate who has been bullied and who has kind of been harmed, has been made to provide favors. He believed he was about to be raped by this bully, and one day when he was on kitchen duty, he came out from the kitchen and poured scalding oil on this person's head, and he said that because he had been beaten up the day before, and then 2 hours before the incident, he had been threatened and told that this guy was going to finish what he started, either a rape or a physical beating. It's not really clear. And the court found that Haynes did not meet self-defense. We are kind of missing some of the elements of self-defense. The court really focused in for Haynes that he could have reached out for help from the guards. He could have defended himself proportionate to the threat. But preemptive strikes are not okay. There's also a chapter in your book called People v. Goats. This is a really famous case kind of dealing with whether or not Goats had a reasonable belief that he was at risk of harm. Goats was on a subway. Some young kids had gotten on. They said, give me $5, and he didn't. He just responded by standing up and pulling out his own handgun and firing 4 shots in rapid succession, hitting some of these 4 youth. He testified that he had been robbed a few times. He thought they were trying to play with him, and he responded in this way. And the question was all about whether or not it was reasonable for him to believe that he was acting in self-defense. He was indicted for possession of a criminal weapon, attempted murder, assault, and reckless endangerment. The indictment was then dismissed. Then the state of New York appealed, and the Supreme Court of New York reverses the order and says that the indictment needs to be restated. This is not necessarily how a reasonable person should act, and we don't want to encourage kind of vigilantism. Self-defense also has a retreat rule that has a castle exception. So in many states, you have to retreat from an attack if you believe you're in danger, unless the castle exception is in play and you're in your own home or it's domestic violence. And then we have a cohabitation exception and a battered women's syndrome exception in some states. Okay. So this is kind of the traditional self-defense. In states that have a stand your ground statute, that alters self-defense in that you don't have a duty to retreat in those states, and it just kind of changes and lessens some of the standards. It makes it easier to use self-defense in a state that has a stand your ground law. Okay. This is pretty confusing, so again, if you have questions, definitely reach out. There's also the defense of others. Traditionally, you can only defend yourself and your immediate family. You kind of need a special relationship. There is some states that have a broader exception. You can exert the defense of others anytime the individual could use it in their own defense. There's also the defense of home and property. And under this defense, you have more abilities to, you can defend your property, but usually you can't use deadly force. With kind of these new castle laws, though, it does give you more flexibility to use force to protect yourself. They kind of expanded their ability to defend your home and property. But usually the general rule is you cannot use deadly force to defend your property. A choice of evils defense has 3 steps. This is times where you are kind of in a no-win situation. It's sometimes called necessity. Under the model penal code approach, you have to identify the evils, rank the evils, and it needs to exist right now. The situation needs to exist right now. Your book has an example. The defendant was convicted of a DUI, and he was driving. He was the passenger in a car, his own car. The driver was a juvenile who had had a couple of beers, saw a police officer car pull onto the road and jumped like out of the car or jumped into the back seat. And so this defendant got behind the driver's seat to stop the car, and then he was charged with a DUI, and he defended, again, he was able to present this defense, so it was up to the jury about whether or not he responded with the lesser evil. This is kind of designed to some examples of times where it's okay to make these choices, or to destroy property to prevent spreading fire, going faster than the speed limit to get a dying person in the hospital, throwing cargo overboard to save a sinking vessel, in an emergency, dispensing drugs to an individual to save their life, breaking and entering into a cabin to avoid freezing to death. Those are all the right choices. Those are all acceptable choices if you're in those circumstances. Under the defense of consent, this is the idea that you voluntarily consented to the crime and you knew what you were doing. So it doesn't need to be voluntary. You do need to know what you're agreeing to, and you need to be able to make the consent. A lot of times this happens in like sporting events, and the example in your textbook deals with a basketball game or someone got punched, and the court finds that that's a part of participating in sports. Again, this was a shorter lecture. My computer requires I keep these under 15 minutes, but we covered quite a bit of ground. So if you have any questions about any of the terms or concepts, please let me know. I look forward to hearing from you guys this week.